Every time you're going to trial, you're saying, we're going to go get more time because we need to look at the discovery. We're going to go do this. And it's getting shut down and shut down and shut down over time. And the whole time your mortality is like dangling over you. He could regret it right now. He could have never wanted to take it before, but during the time period that he took it, he took it. He could hate that he did that.
And here we go.
Welcome to the freak show, the best in town.
You guys have been on an absolute terror in the best way. You guys are on fire, and I'm excited to have Ron here as well. So thank you for coming back into the Hive and chatting with me.
Ron is one of the few dual certified specialists. So he's a California family law specialist, but he's also a California appellate specialist. So for as long as I can remember, Kristen and I have been running to him with our litigation questions. And so we're so happy that he agreed to join us.
Tonight, we're going to be talking about what can Bryan Kohberger do with post-conviction relief. And we're also going to be talking about the WSU lawsuit. So he pleaded guilty.
Mm-hmm.
It doesn't sound like anybody's coming to save him. The news hasn't changed. The narrative hasn't changed. Where are we at?
He's past the time to directly appeal his plea and his conviction. That was 42 days. And so that expired, I think, September 3rd. So he's now in an area where, number one, and this all assumes that he's going to be the one that does this. And frankly, I don't know that he's in a position right now where he wants to. I was surprised at the guilty plea in the first place. But he could have potentially filed a motion to withdraw of his plea. That's passed. He could have, he potentially, and I think still, well, that's actually the deadline just passed to reduce his sentence. So he's into, it's called the UPCPA. Don't ask me, it's a post-conviction statute where he can essentially, from now until September of 2026, he can challenge based on ineffective assistance of counsel. He can challenge based on it being an involuntary plea or waiver. That, I think, is potentially where, if something were to happen, if he were to make such a motion, that would probably be the ground, because I think that's what's happened here. So he's been coerced, I think, into this. He could challenge it as being an illegal sentence. I think that's a non-starter. Potentially new evidence. And you know, if it comes out that exculpatory evidence was withheld, he could potentially bring that then to the district court. This would go to Judge Hippler, but he could then appeal whatever ruling that is if that doesn't go his way.
One thing, first and foremost, when you say ineffective counsel, what do you mean by that?
Ineffective assistance of counsel, that's something that is available to virtually every criminal defendant that has counsel. That means that essentially it's kind of like malpractice for a criminal attorney, that they did something something wrong that essentially made his representation ineffective and resulted in a guilty plea or a guilty verdict. He potentially could bring that up with regard to getting into the guilty plea in the first place, and if he feels that his counsel did not appropriately represent him and did not appropriately counsel him on that.
My question with that is, with Ann Taylor being his current counsel, does that prevent or present a potential conflict? Because
No.
Does it require her to make this argument against herself, or does he have to have the wherewithal to have the advisement from her or from another attorney?
No. In fact, if during that, for instance, during that first 42 days, he asked her to file a notice of appeal, even based on that ground, and she didn't do it, he could raise that now as an ineffective assistance in counsel. She's required to do that. And in fact, I've heard a number of defense attorneys saying that there are times they encourage their client to do that. They'll just tell them, you need to file a claim for ineffective assistance of counsel. I think it's something that's so widespread in criminal practice that I think most defense attorneys expect that's going to come at some point. And frankly, I can see why a defense attorney might use that in trying to help their client. I don't know that there's necessarily any negative, anything negative that happens to the attorney in that case. But yeah, if he asked her to do that, she would do that. And I would expect she would advocate it very strongly.
Can I kind of back up from what we were just talking about and ask, why would an innocent man take a plea deal? Because I think that's really hard for a lot of like normal people to wrap their head around.
Maybe you're in a jurisdiction where juries are much more likely to convict, or certainly not afraid to convict. You could have a judge that seems to be favoring the prosecution in what evidence is going to come in. You have evidence that seems pretty strong, and you have to weigh, if you're the defendant, do I want to risk the death penalty, or should I just take a plea with the promise that I wouldn't have the death penalty? It would just be life in prison.
Yeah. And just to add on to that, I mean, I think when you're looking at a courtroom venue, there's always a risk analysis about it, no matter what. Like in family law, we do it all the time. We're out in the hallway with a client. We're like, look, this is your potential settlement, or you can roll the dice. You can go to court. Maybe you have a good case, but you could still lose. And that's always present, especially when you're up against potentially the death penalty. And then I look at it like, okay, we've all sort of publicly watched the litigation that occurred up until the time of the plea. Well, what about the fact that it didn't seem like it was going his way very much, right? Like he was denied for the ability to have the alternate suspect theory. He was the judge was denying more time for the trial to go through the discovery. Like all of these things, the lack of potential confidence with Ann Taylor, like all of these potential things over days and weeks and months of your life starting to, maybe feel like, hey, I'm not going to have a quote unquote fair trial. And even if I did, do I have any chance of it actually going the way I want it to? So I think it's not that confusing that someone would take a guilty plea, especially like Ron said, you're avoiding a firing squad. And that's just on its base. You're suspending the idea that he could be pressured by someone in prison, people outside of prison, his family, even just the pressure of his family being concerned that, Kristen said this before, his family being concerned that maybe this wouldn't go the way that he wanted to and he would get the death penalty.
Imagine his mom having a heart-to-heart with her son. I mean, they've been very quiet throughout this entire process, BK's family, but obviously we don't really know what's going on behind the scenes. But his sister showed up on the witness list for both parties. I know that his mom was being considered at some point to be on the prosecution's witness list. I mean, as a mom, couldn't you imagine her going to her son and saying, I just want you to stay alive. Whether that's, in prison or out, I thought about that. Sam actually brought that up yesterday. And I said, that's a possibility too.
When you are an attorney and you're going into a courtroom and you're regularly in front of a judge and you're not going anywhere, it's going to, even if you don't want it to, even if you express all this confidence, it's going to chill your ability to feel like you can have a fair trial. And I think that does weigh heavily on it. Every time you're going to trial, you're saying, we're going to go get more time because we need to look at the discovery. We're going to go do this. And it's getting shut down and shut down and shut down over time. And the whole time your mortality is like dangling over you. And I also just think when you think about a plea, it's not necessarily a moment in time, but it's a small period of time. He could regret it right now. He could have never wanted to take it before, but during the time period that he took it, he took it. He could hate that he did that.
Okay, here's a question we get often, and frankly, I would love to have you explain it. When you file the appeal, what happens? Does a panel of appellate justices review? Do you get an oral hearing? Do they deny it on the face and you don't get an oral? Walk us through that.
Yeah, and I know the California procedure. I have done federal appeals. I've done some in the 6th and the 9th Circuit a while ago, and they're relatively similar. The whole process across the board is pretty similar. You file a notice of appeal, identifying what ruling you are appealing. Then there will be some time putting the record together, and then you'll file your appellate brief. I know in California, we have a 14,000 word limit that usually comes out to somewhere between 50 and 80 pages of a brief. And then the respondent, if it's the state or the defense, usually it would be the state, they get to file one, and then the appellant can file a reply. Then when it's fully briefed, it'll be assigned to an argument panel, which is usually in, and I'm trying to remember, I think in federal, I have argued in the Sixth Circuit. I think that was also three justices. I think it's usually three. So you argue in front of a panel of three justices. In California, we get up to usually up to 15 minutes per side to argue. It's a very brief. It's California
15 minutes to prove your client didn't
yeah
unalive 4 people. Wow.
Yeah. Sometimes if it's a complex case, you can request usually up to 30 minutes or more. But most of the criminal, actually, usually the criminal appeals that I watch, and I sit in court and watch a lot of them, are a lot shorter generally than the civil appeals. But they rule primarily on the briefs, and they'll tell us both in the training and that we get, and sometimes from the bench, counsel, we've read the briefs. We don't want you to regurgitate your brief. Is there anything else you want to point out? That's why we get just limited time to argue. But that's an opportunity for the justices. Sometimes if they're in disagreement, they'll
is it a majority opinion or?
Yeah. So there will be 3 justices, and at least 2 have to join in the opinion. The other can write a dissent if they choose. If they're in disagreement about how it should go, they use that sometimes as an opportunity to try to bolster their side or sway a judge on the other side. And then they'll issue an opinion within usually 30 to 90 days.
Ron, are there any exhibits that are attached to the appellate brief to support the brief?
There's a record. You will designate certain pleadings, exhibits, things that were presented to the trial court. In the case of appealing a jury verdict, you'd include the exhibits, the jury instructions, and so forth, and also a reporter's transcript, which is a copy. There's a court reporter that's taken down everything verbatim as it's said. That's also put together in a reporter's transcript, and all of that goes to the appellate court.
Okay, Ron, I have a question.
Okay.
If it came out that the DoorDash order and delivery was fake,
Mm-hmm.
could that potentially, which that's one of their main witnesses, right? I think that the DoorDash driver and DM and BF, those, I mean, that's what kind of they're hanging their hat on. But if there was evidence to support that entire order and delivery and storyline that they had put out was fake,
Mm-hmm.
do you think that would be grounds to file an appeal?
If it's a material part of the case and it is it being false or fake would cause prejudice. That's the big bugaboo for appellate attorneys. Is we can prove that there was error in some way. We can prove that the judge did something wrong or that the evidence was wrong, but we also have to prove that it prejudiced the appellant. In fact, I had an appeal that came down just recently where they said, you're right, Mr. Funk. The judge was wrong in this. The judge was wrong in this. The judge made an error here. The judge made an error here. But we don't think it was prejudicial.
What about the denial of alternative theories?
Suspects, yeah.
Yeah, and I looked at a little bit at Idaho's statute on that. It seems to me that what I read of the statute and what I heard coming from the judge on that issue, I think the judge seemed a little stricter to me than the statute requires. There just has to be some factual basis for them to allege that. So yeah, that potentially could be an area where there was legal error. And if the plea was based on that, sure, potentially you could do that. In fact, legal errors made by the judge are one of the best grounds for an appeal, because then the appellate court can look at that, what we call de novo. They look at that just fresh. They don't have to give deference to the judge in that case. They can say, well, here's the evidence. Here's the arguments. I don't care what the judge said. I think he was wrong. This is how it should have been. And by the way, that was prejudicial because we think a different result would have happened had the judge made the right ruling.
Bertie, correct me if I'm wrong. When they were doing the hearing about the alternate suspects, it's my understanding that Hippler, the judge, basically came down and said, there's not enough evidence for us to believe that this is a potential alternate suspect who committed the crime. And by the way, I'm not using exact words, but by the way, they didn't do it because they're all in walking distance from the King Road residence.
Well, it was essentially the reasoning that the judge gave for the alt perps not being enough was the exact same reasoning that any defense attorney would have said Bryan didn't do this. Even the DNA likelihood ratio, right? Yeah. He falls right in the middle of all of them when it comes to the actual alt perps laid out. His likelihood ratio is in the middle of all of them. I put out a TikTok, a couple months ago about that, showing, the point, whatever it is. I don't remember off the top of my head, but it's crazy to me because I hear you guys talking about this and I hear this complex legal system. And in my head, while it's very interesting, I want to learn this. In my head, I'm going crazy because I'm like, why isn't anybody defending him yet? Why is nobody stepping up to get Bryan Kohberger out of prison right now?
Well, we don't know that nobody has stepped up. We don't know. Mm-hmm. Again, speculation, opinions, just observation. I think it is quite possible that Ann Taylor is working with some sort of appellate firm, okay, like the Innocence Project. There's a whole bunch of those, but it has to be someone with deep pockets, has to be someone with the manpower to do what needs to be done. But I believe that conversation has probably been had, and I believe that they might just be gathering all their evidence. As an attorney, I don't want the other side to know that I'm coming onto the case until I want them to know. So if a client hires me in a domestic violence case, but I need to gather all of this evidence, I'm not going to file a document that tells the world, hey, I'm representing so-and-so. So I think that there is a potential that they are in the fact gathering, that they are in the investigation process, and they are doing what they need to do, but the whole world just doesn't know about it yet.
I agree with you, Kristen. I just don't want them to be lapsed in any of those statutes of limitation.
No, I agree. I agree.
I mean, guys, we have no blood, no fingerprints, no knife. There's no confirmed hand. You can't put him in the house. He didn't stalk the victims. There's no confirmed handling of the murder weapon that they never found. What are we doing? You can't see his license plate. You can't put him in the house. Sorry, Ron. Go ahead.
Oh no, I'm saying that's why he shouldn't have pled guilty.
He's an idiot. At the end, maybe not.
Maybe.
I'm sorry. That was like, that's like where my gut goes is like, if he's really just doing this, there's got to be a damn good reason. Because if this is a straight up case, right? That's not smart to do.
Yeah, no.
So Ron, what if Dylan came out and was like, it wasn't a dream. I just have a loose relationship with the truth and I'm not credible. And you should ignore everything I said.
I don't know that necessarily would work for him because we didn't have a trial. And so we can't say that the plea was based on what Dylan said. And from what I've heard, in fact, I think Kristen said this, or maybe it was you, Sam, that Dylan was said to be the least credible witness with a grand jury. So I don't know that necessarily would help. Something that would help is, well, if someone came forward and said, no, he didn't do it, I did it. That might, that would probably help.
Yes, that would be very
Or
helpful.
if it comes out that there was blood from other people that was never turned over, or the evidence.
Like the other DNA that was, the other unknown male DNA that was on I think it was the sheath, right, Bertie?
Well, there's unknown male DNA in a couple places, right?
And
like
on
you
the
have
wall,
the handrail,
right?
you have the wall, right? And I think too, just real quick, Shoe Girl said he's not an idiot though, and obviously Shoe Girl's Dana, great relationship with that. But I just want to say, you're right, he had no choice, and that's what I was kind of saying is like, if this is a straight up trial, he's gonna get a fair trial. That plea deal should have never been accepted, especially given the narrative that is so locked tight around this guy. Why would the state ever, after wanting to make an example out of him, building a murder room where they press a button and this guy gets shot in a room in a firing squad, right? Why would they ever just take that off the table, given what they told us leading up to this plea happening and what they had on him? Just for them to come out and say, we can't put him in the house?
There was no smoking gun. There
That's
was
crazy.
no, I was waiting for it. I was like, please tell me and Sam that there is something that they have that we don't know about it. And it's going to be announced right now. That's going to change all of our minds. Because if he didn't, then we're good with it. Right.
Again,
And
no blood.
I heard that sentencing or that plea, the change of plea was just like you say, Brittany, we can't put him in the house. We actually only have exculpatory evidence. We don't really have anything that 1000% beyond a reasonable doubt. That is the most important piece of this puzzle. Sam says it all the time, beyond a reasonable doubt.
So let me
connect the dots.
And to go off of that, just again, I'm not a lawyer. I don't know the law. No blood, no knife. Okay. The witness can't identify him, and his phone doesn't put him in the house. He never stalked them. Like, what are we doing?
Yeah.
That's crazy. Like, the fact that we're all debating, and this is not disrespectful to anybody, but I'm like, we get into this legal mess for what reason? This is crazy if you look at the evidence.
Well, I wonder if there's something more to the timing too. I mean, when you think about creating a perfect storm, you have a media frenzy while you simultaneously have a non-dissemination order that's making everyone go, he's guilty, he's guilty, he's guilty, he's guilty. Then you have some pretty good wins in court where he's going to be limited in his ability to bring forth evidence. And then right before we're actually going to go, okay, let's go to trial, and continuance is denied. Right before you're going to go to trial, maybe they're a little concerned that the evidence they have is not actually going to convict this guy. So for the first time ever, they say, you know what? Last chance, buddy. Now or never. We'll take the death penalty off the table, sign here, and this will go away because we already got you. There's probably some puffering there, you'd think.
Oh, I think you're 100% right on that, Sam.
And we also don't know exactly what the defense had versus what's coming out. It could be that some of what's coming out, the defense had. So I think that's going to be a key is as stuff comes out later on, is it something that the defense didn't have? Those are the things that you're going to look at potentially with challenging the conviction.
Well,
and isn't Ann Taylor, Bertie, isn't Ann Taylor still of the position that she didn't receive, that she's still waiting for some stuff that she either A, was entitled to automatically or that she asked through the discovery process? I believe that's still her position today.
That is still her position today. And to go off of what Ron just said is, well, and again, I'm going to back up. You're kind of alluding, in my opinion, what we're all alluding to is like, why all the secrecy if this is open and shut? And the big secret is not the secrecy if this is open and shut. The secret is that they all know it's not open and shut. And that's what's so crazy about this case. This is not straightforward. We've had thousands of documents. How many hours of audio and video does anybody see Bryan Kohberger shuffling around Linda Lane or the car park or anywhere on 1112? No, you don't. You look at him walking to Costco, you'd recognize that lip walk anywhere. You know what I mean? Yeah. Like, and you don't see him.
It's almost like all of the additional evidence we have, none of it points to him.
No, they put a gun to his head with the death penalty, literally.
Mm-hmm.
Pretty much.
And that's sick, dude. That's so messed up.
But he went to Costco, so he must have done it.
And they put a gag order in for narrative control around it.
Yeah. Gag orders aren't unusual, but what I'll say is if I hid evidence or I didn't cooperate with discovery, I certainly am not going to make it easy for that to come to light later on after the case is all done.
Wouldn't you not seal stuff with a gag order though if your case is strong? Wouldn't you only seal it if it's weak?
Well, that's hard, right? Because there you have to circle back to the impossible mental gymnastics of not wanting all of the evidence to get out, people to be considering it that would otherwise be juries, to allow someone to have a fair trial. And by the way, it's not just the juries, it's the witnesses. Do you want your witnesses to have been able to review all of that evidence and consider it and line up their testimony? So there are legitimate ways that it can compromise a trial. I'm not saying that this is that. There is the potential for that. I think my problem is because of the potential for that, we're all throwing it under there and saying, well, duh, this is why we haven't done it. And it doesn't always make sense in every case. It's not totally applicable.
And
So
the
if
gag
it's-
order has been lifted. I know there's a couple comments about
Right.
that, but the gag order has been lifted. And there's a couple other comments too about a special counsel. At some point, Hippler was talking about appointing a special attorney to look into the leaks. But to my understanding, Sam, Ron, correct me if I'm wrong, that never actually happened. Or maybe he appointed one and then the plea happened. But I don't really think much came of that.
Right. And I understand that we're talking, in the majority of today where we are at, but the gag order to begin with, right? Like that's just, if this is a drug hit, how many drug hits happen every weekend all over this country? Is there national security and sweeping gag orders and national attention on all of them? Not really, if ever. And it's like, why this case? Why is this case just gained momentum and steam? Why is there the drama around the leaks? Why is Amazon, Dateline, all these people putting out, these series? I've always thought the weirdest thing in the world to me is that Amazon, think about how much effort they put in to prep a 3-part series on this. Lining up the interviews, scheduling them, editing it, promoting it, producing it, getting it ready to go. And Bryan just so happens to plea out 2 days before their release date when they're saying that we're going to have never before heard evidence in this. That's weird. You got a book, you got Dateline, you have all these people talking. I don't get it.
Well, I think the amount of coincidences are so overwhelming that it's just like, I don't know the statistics, but I mean, how could this be possible? How could all of it be possible? And I think that that's the reason why there's so many people whom, by the way, I've never really heard from Bryan or what Bryan has to say. He probably's got something to say that would be pretty important to hear, that have all started to conclude that this doesn't smell right for whatever reason. I think it's hard to keep just ignoring each and every coincidence to me. It's just there's too many in a row.
I agree. And that's where I think that I butt heads with people is my brain goes away from this is a normal case. And it actually goes to this is anything but a normal case. This is something where it's like people say, well, they can't lie in court documents. Okay, go read the 9/11 Commission report. Go read JFK. They would never fudge the time. Are you kidding me? You could wipe your ass with the commission reports.
And the PCO has to be completely
family law attorneys here. How often in an average week do you have an opposing party or someone lie under the penalty of perjury?
That's what I'm saying.
Thank
you.
And if they're not lying, they are overly dramatizing it so much that you have to come to one conclusion. But I always like just putting it right back. Oh, so counsel, you were there when this happened, correct? Because that's what you're inferring.
And you're saying that could be written on paper and still be a lie.
Oh yeah, they'll have above the signature. It'll say that they're writing this under penalty. Not so much the attorneys, but the parties are saying that, which then the attorney is relaying that information. But so many attorneys almost make themselves a witness by saying this happened and this is how it went down and this is who was there. And my first question, all three of us would be like, okay, so you were there because clearly you are highlighting this as if you were there. And no offense, but parties lie all the time.
I may or may not have called an opposing attorney a liar from counsel table in front of the judge on more than one occasion.
Yep. Good old Ron Funk.
Yeah.
Walk out.
I have clients come to me all the time and say, she lied. What can we do? Can we hold her for perjury? And I have to tell them, look, family court people lie all the time.
And that's without national security, by the way.
Yeah. They would, the courts would be inundated with perjury cases if they prosecuted them for lying. And
you would be
it
shocked.
just, as a practical matter, and I can say this, I sometimes a couple times a month I sit as a temporary judge in Riverside County. And I had a case recently that I was the judge on. It was two people who were in pro per acting on their own without attorneys. And the question was whether the ex-husband kicked the door. And he said, no, I didn't kick the door. I did not. And then the wife says, well, I have a video here. Okay, well, let's see it. We saw, and he's kicking the door. I'm like, dude, you lied. But honestly, that didn't really play into the decision. It's just as a practical matter. You can't get too it happens too much. And I think a lot of judges are like that. It's like, yeah, of course somebody lied. I think the important thing is that in the end, we're trying to get to the truth one way or the other. and the idea is, yeah, okay, that's a lie, that's the truth, I'm going to rule based on the truth.
Yeah, and to the point that anyone's making that people don't lie in court, like that's one of the major points of a trial. Depending on who has the burden and what you're doing, you're putting on evidence to prove your case, but you're also putting a witness on the stand, and you have a right to confront that witness. And the part of the point of that is to see if they're credible and have the jury or the judge, depending on what type of matter you're in front of, weigh or decide whether that person lacks credibility or not. Because a lot of these things, even in a murder trial, are he said, she said. Of course, there's also evidence, but it's no, I didn't do it. Yes, I did do it. And who is more believable? So, I think it is understandable that people think, well, no, not, the legal system, everyone tells the truth, but people lie. People lie a lot. And a lot of people lie for no reason.
Thank you to Sam, Kristen, and Ron. You guys rock. Thank you.
Right.
Cheers. If you have not hit that like button, guys, please go ahead and do that. HiveMindStore.com. The grand opening was Sunday. All of the merch comes from our Discord. And so thank you to everybody that's made that great and special and awesome. And thank you to everybody that already has placed an order.